All right, we will get started because we have a tendency to run over with some of these, so we want to give Greg as much chance as we can. Thanks so much for joining us today for a right to know what human trafficking survivors and their advocates need to know about monetary remedies in the law with Greg Zarzar. My name is Renee Williams. I'm the Executive Director of the National Center for Victims of Crime. A few quick housekeeping items for today's webinar. Several hundred of you are on the line, and that means things for us can get a little unwieldy. So what we do, and this has worked pretty well for us in the past, we're going to keep everyone on mute throughout the entire session. We'll keep that chat function open for everyone to talk amongst yourselves, but we will not be monitoring the chat for questions. Instead, what we're going to ask you to do, if you hover at the bottom of your Zoom screen and you see that black ribbon, there's a Q&A function. We will be monitoring the Q&A function only for questions, but again, we will keep the chat open for you all to talk amongst yourselves. If you have a question, please go ahead and use the Q&A function. We'll take anything urgent in real time, but I'm going to save many of the questions for the very end. Greg has very generously agreed to stay on for an extra 15 minutes to answer questions live, and he will also answer questions via email if your questions do not get in. We will send a thank you for attending email to all registrants, but no certification is going to be provided for this. There won't be a certificate of completion or anything like that. Finally, this session is being recorded and we will make it available. It'll either be accessible on our YouTube page by searching National Crime Victim Bar Association or on our website at victimbar.org. With all of that, we are so pleased to introduce Greg Zarzar. Greg is a founding member and the lead trial attorney at Zarzar Law. For the past 20 years, he has almost exclusively represented individuals that have been injured by criminal or the wrongful conduct of others. More recently, he's been very active in educating his colleagues and attorneys and victim advocates about ways to help human trafficking and child sex abuse victims. He is one of only a few attorneys in Alabama that we have as recognized by the National Crime Victim Bar Association, and he's dedicated to increasing awareness for crime victims' rights and assisting such victims in maximizing any recovery they're entitled to. I will say he is one of our favorite members, and it is always a pleasure to work with him, and we're so grateful to have him here. So welcome, Greg. I'm going to turn it over to you.
Renee, thank you for that introduction. And first of all, let me say thank you to everyone in attendance. It's my understanding that a good majority of those who are attending today are what I like to call first responders, advocates, victim advocates, law enforcement officials, district attorney, victim advocates, NGOs. And while the news is predominated with the COVID-19 pandemic right now and the good deeds that are being performed by the frontline workers in healthcare and elsewhere to address that pandemic, candidly, for the last 20 years, this country and the entire world has been dealing with a human trafficking pandemic. And those of you in attendance today have been on the front lines and should be thanked for what you've been doing to address such a horrific human rights issue. I am going to start by talking about what I will not address today. And that will not be the criminal process. So obviously the number one thing that people think about when they think of human trafficking is that it is a crime, and it is a crime. And that there are criminal penalties for those persons that perpetrate or commit that crime. We will not be talking about that process today. Nor will I be talking about the monetary remedies that are available within the criminal process, which is called restitution. That is, in most federal trafficking cases, something that is mandatory for the victim to receive restitution. And that is part of the criminal process. Our focus today is going to be on the federal trafficking statute, which is a part called the TVPA by initials, the Trafficking Victims Protection Reauthorization Act. And before I talk about that act, I need to do a little bit of a history lesson. Back in 2000, Congress passed what was called the TVPA, the Trafficking Victims Protection Act. And that was the first sort of comprehensive law in our country to criminalize all forms of human trafficking. If you look at the law prior to 2000, to have a criminal action against someone who would have done something that amounted to what we know as human trafficking, you generally needed to be able to show physical force or some abuse of the law to charge that person with a crime. When Congress passed the Trafficking Victims Protection Act, it sort of consolidated the human trafficking crimes in one section, which is generally referred to as the Chapter 77 crimes. And it also recognized that the reality is a little bit different nowadays, that trafficking can occur in more subtle forms. And so the law that was passed in 2000 included force, fraud, or coercion. So coercion obviously is a little bit more of the nuanced ways that people are controlled and trafficked. And so that was an important thing. That law, however, did not include a civil remedy. It did define trafficking in those sections that are identified on the slide here today, both forced labor and sex trafficking. However, in 2003, Congress reauthorized that law. And in doing that, they added a civil remedy to the trafficking law. And that is Section 1595 of the TVPA. I think it is fair to say that Congress recognized that prosecution alone was not going to be enough to address the crime of human trafficking that was so widespread. That was asking too much of law enforcement, asking too much of our U.S. attorneys' offices and various prosecutors throughout the country to say that the only way to address this problem would be through criminal courts. Candidly, civil courts are a great way not only to compensate a victim or survivor, but to deter conduct. When you let the trafficker know that they can't afford to do what they're doing it, they're treating people like commodities, as horrific as it sounds, for the purpose of making money. If you can attack that purpose, the motive itself, and go after the money, and go after those that have enabled the trafficking to occur, you can have a greater societal impact on deterring trafficking as a whole. I will tell you that in 2003, when Congress added that remedy, it was important, but in my mind, it only slightly opened the door to the types of claims that civil lawyers like myself could bring on behalf of survivors. 5 years later, in 2008, Congress again amended the TVPA, and specifically they amended Section 1595, the civil remedy. And in that amendment, I think they have kicked that door open wider. They've given the civil remedy some teeth so that survivors can not only sue those who have sort of criminal culpability, the perpetrators of the traffickers, but the 2008 amendment was important because it allowed for a survivor to sue anyone who received anything of value or knowingly financially benefited from a venture that that person knew or should have known was engaged in sex trafficking or labor trafficking, was engaged in any violation of the TVPA. The knew or should have known standard is important because the underlying criminal statutes themselves have a knowing component. Lawyers use the term mens rea, a criminal intent. The should have known standard for the ability for a survivor to bring a civil claim introduces what we call the negligence standard, which is a little lower than the criminal standard, the knowing or willful blindness that sometimes is required to show more intent. Should have known that Congress added in the 2008 amendment introduces into the civil remedy the general negligence standard that is typically applicable when a civil lawyer brings a claim against someone or some entity for negligence. They didn't act like a reasonable hotel. They didn't act like a reasonable employer. It is more of a reasonable standard as opposed to a criminal standard. In addition, the Section 1595 civil remedy for claims brought by a survivor, by a civil lawyer in a district court, United States District Court, a survivor has 10 years to bring one of those claims. Again, I think Congress should be applauded for the length of time they've given here. Obviously, all of us would like for it to be longer, but the fact that it is as long as it is a testament to Congress realizing that some survivors will need time before they are in a place where they can exercise their right under the civil remedy provision of the TVPA. If someone is a minor at the time that they are trafficked, their time for bringing a claim is told or paused until they reach the age of 18. And then that clock starts to tick on when a claim can be brought. I think it's also important because human trafficking, the crime of human trafficking, is unique in that both federal law has criminalized it, but also now more than 40 states have passed individual human trafficking statutes that not only criminalize and identify what is human trafficking under state law, but they also have a civil remedy provision built into those various state laws as well. We will not be, it would take up our entire time here today if we were to try and go through each of those various state laws and how they're worded. I am happy on an individual basis if anyone has a specific question about a specific state to address how a specific state defines human trafficking, how their civil remedy provision works, and what the statute of limitations or the timeline or deadline for filing a claim is under those specific state statutes. But for our purposes today, the federal remedy, which is applicable to every state, is Section 1595, and it has a 10-year statute of limitations. So where is human trafficking? It's everywhere, candidly. This is a Polaris Project map they call a heat map from where their calls are coming from to the human trafficking hotline. Clearly, every city, every town in America has a human trafficking problem, and it is important that advocates in every place in our country be aware of the civil remedy provisions. And I say that with emphasis because even lawyers that I speak with frequency have no idea that the human trafficking criminal laws have a civil remedy component to them. So the fact that everyone of us may not have been aware that there's a civil remedy provision as it relates to human trafficking should not be a shock, because lawyers did not realize it. And in fact, the numbers sort of demonstrate that. That civil remedy provision has been around now for 17 years. And until recently, it was rarely used. I believe the last count that I was able to review, that in sometime in late 2018, even though that remedy provision had been around for 15 years at that point in time, there had been less than 300 cases filed throughout the country. So clearly we have a resource, a tool in the toolbox to address this issue that is being underutilized. And it is not only a tool that can help combat the crime, but it is one of the better tools to help the survivor. It is actually an opportunity in the right set of facts, the right circumstances, to essentially give a survivor a chance at a new and free life. The ability to pay for the long-term care that we know that anyone who's experienced that type of trauma may likely need. And that is...
Hey, Greg?
Yes.
We have a specific question. What is this map showing? Can you clarify? Is it trafficking cases reported to police, actual prosecutions for trafficking? Do you know how this map was created and what was being measured?
Yes, and so this map is from the Polaris Project, which is one of the leading NGOs as it relates to the fight against human trafficking. And this heat map is identifying locations where calls have come in to the National Human Trafficking Hotline. So that is where obviously the concentrated areas clearly along the East Coast, down in South Florida, and along the West Coast. But this map is to show that calls are coming from every state in our country. So why should every survivor consider filing a civil case? The list goes well beyond this slide, but these are some of the major reasons. First of all, the TVPA, which we discussed, included a civil remedy. And in that, there was a goal built into that. And first and foremost is to compensate the survivor. Damages are available for a survivor. Separately, a civil case is a means and a way to empower the survivor, to give them control. Obviously, it punishes the trafficker if a trafficker is a defendant in a civil case. It punishes any company or person that financially benefited from a trafficking venture if they knew or should have known that they were benefiting from a trafficking venture. And obviously, civil verdicts traditionally have a deterrent factor, that lawsuits, the judgments and settlements that result from lawsuits will deter similar conduct in the future. If one rogue employer is trying to cheat the visa program and employ folks in a forced labor type situation, a significant verdict against that employer will obviously deter other employers from similar conduct. So there are these overarching reasons why every survivor should consider filing a civil case. Not every survivor will have a civil case that ultimately is in their best interest to pursue, but they all have a case and they all should consider filing a case. This is taken from the Human Trafficking Institute's, they do a report each year. This is from their 2019 Federal Human Trafficking Report. And it's really an analysis of the criminal cases. And I know we're here to talk about civil cases, but in large part, because we know there are not a lot of civil cases filed, it helps us to look at the underlying criminal cases to get some better appreciation as to how it is that certain persons are more vulnerable to being trafficked. And clearly, as far as the criminal cases in 2019, the leading underlying vulnerabilities are listed here, with drug addiction and substance abuse being the number one method by which someone was vulnerable to being trafficked. Clearly, runaways, children that have been previously victims of child abuse or neglect, undocumented persons are especially vulnerable, and anyone who's been through a prior trauma, which is why previously trafficked, someone who's been through an abusive situation, either as a child or as an adult, and then children in the foster care system. A lot of times we have seen that persons who are re-entering society after having been in prison are also especially vulnerable to being trafficked for a lot of reasons, and some of them being that they don't have necessarily the opportunities that someone who has not been in prison would have as far as traditional employment opportunities. I think it is important for me to sort of point out a little bit of a dynamic that is interesting to me. Until recently, the majority of civil claims that had been filed by survivors of human trafficking have been filed by survivors of labor trafficking. And the reason I think that is an interesting dynamic, because the reverse is true as it relates to criminal prosecutions. The majority of criminal prosecutions have typically been in sex trafficking. I think some reason for that might be, obviously, that prosecutions are typically focused on punishing a wrongdoer, an individual. And that is more precisely done in a criminal context where you can charge a particular person with a crime. And civil cases, because ultimately the only thing that a civil claim can ask for as far as a remedy, and aside from injunctive relief, is monetary relief. And when you're asking for money, typically you need someone who has the means to pay a judgment that would be substantial enough to make a meaningful recovery for the survivor. So the labor context generally necessarily includes that there is some employer, some company involved. And I think that may offer some explanation as to why there has been that disparity in the civil cases that have been filed that are distinctly different from the criminal cases that have been prosecuted. Nevertheless, in both situations, in both the civil case, an individual trafficker can be sued and has been sued. And in a criminal context, an entity, a company, can be charged with a crime. And they have been charged with crimes in the past. So just because it is more the norm for an individual to be charged with a crime and a company to be sued, both an individual can be sued and a company can be charged with a crime. Focusing on the industries again, borrowing from the criminal cases in 2019, where we are seeing labor abuses that have resulted in criminal charges, obviously, which would be also where those survivors might be that would have a civil claim. The bulk of those in 2019 were domestic work, and that has traditionally been the case. Domestic work, agriculture, and hospitality have in large part been the major industries where there have been forced labor, labor trafficking abuses. It is not limited to those industries, but for our sake, being able to use data to identify where survivors may be, or where victims may be exploited, it helps to look at where the criminal charges are coming from. An interesting note about this that I think deserves some discussion is that it is not limited to just the employer. We have obviously seen cases in the past where a recruiter was used. So in those contexts, if there's a recruiting firm that uses fraudulent methods to get someone into a situation, whether it's a modeling agency, a recruiter for a hard labor job that recruits international workers to come to our country under sort of false promises about the ability for a path to citizenship, whatever it may be. And a lot of times folks will get themselves and their families into sort of a debt situation to borrow money for an opportunity like this. And then when they find themselves in that opportunity, the debt and the threats related to that debt force them into forced labor situations that they cannot get out of. I will discuss what I think are sort of two of the main cases from both a labor context and a labor trafficking context and a sex trafficking context in more detail a little bit later. But in the labor context, generally speaking, you find folks who are having to work for little to no wages and in deplorable conditions. A lot of times, the little to no wages can be somewhat deceiving. You will find folks who are recruited to work, say, for example, through a J-1 visa program. A student comes over as an international student to have an authentic experience in America, and they find themselves in a resort town at a resort location working in housekeeping, where they're changing sheets and doing laundry all day. And then in addition to that, they are being charged for where they're staying. They're being charged for their uniform. They're being charged for their food. And the net pay is little or nothing. And so you've got, essentially someone here who, by virtue of how they were recruited here, are forced to stay in that employment situation, but they're making no wages. Again, borrowing from the criminal cases to sort of help us identify how it is that people are being trafficked. And this goes back to the nuanced addition of coercion as a method of controlling or trafficking someone, and why this crime is sometimes hard for people to understand or appreciate. That it doesn't always mean that there is force or restraints used, and rarely that is the case. It is more about controlling someone, like we said, with someone with a substance abuse issue. But clearly, for folks who are undocumented or foreign nationals, the threat of deportation, taking their papers, and exploiting their inability to effectively communicate are ways by which people are coerced or defrauded into situations where they are being trafficked for labor purposes. Other coercive means for folks that are not necessarily undocumented or foreign nationals is this idea that you will not get paid if you don't do it. People need to survive, and earning money is one way that is a way for people to survive, and it is withholding that a lot of times forces someone to do something that they ordinarily wouldn't do, or in an involuntary type situation. Clearly, physical isolation, whether it's setting up what has been commonly sometimes referred to as man camps, where there's a need for excessive labor in a certain context, in a hard labor context, where they're isolated, or even isolating a survivor or a victim of sex trafficking from their family and friends, so that there's no one that they can reach out to or communicate with and they're essentially trapped. And then the last three are commonly the more traditional and understood methods of using physical abuse, threats of physical abuse, and verbal and emotional abuse. I've pulled this graphic from the Department of Labor because I think it's important for all of us to take a step back and think about that we probably all have something in our possession and own something in our possession that is the fruits of forced labor, child or forced labor. And because of that, I think that the civil remedy provision is something that needs further use, because downstream, and more precisely upstream in a supply chain, if a company knows or should have known that there is child labor or forced labor in their supply chain, then they may have exposure under the TVPRA, and more specifically to a survivor, they may have a right to bring a claim. Our news feed is filled with various stories about trafficking throughout the world. It is clearly something on the minds of every one of us now in the COVID-19 pandemic. People are even more susceptible to being trafficked. This leads me to, and I think nothing says it more than now suing the traffickers and suing those that have violated 1595's provision about knowingly benefiting from something you should have known was trafficking, is becoming something that is more widespread and known. And it is webinars like this that increase the awareness of the civil remedy. And I would challenge everyone that is tuning in today or listening later, if you can just help identify for one survivor that you may come in contact with, that they may have a civil case, if just the audience, just 1/3 of the audience that registered for this event was able to do that, that would lead to the screening of more cases than were filed in the first 15 years of the TVPRA civil remedy provision. That's why, and that's my hope for this seminar, is that everyone listening to me right now can take away from it the knowledge necessary to help identify when a survivor that you may come in contact with may have a civil claim that is worth investigating. And candidly, I think most every survivor should have the right to have their civil claims looked at. This is going to lead me to a short video on a play for you about a case that is commonly referred to as the Signal International case. And it is about a bunch of Indian guest workers who were brought here after Hurricane Katrina, and they were brought here under false pretenses and false promises of the potential for permanent citizenship. And this short video sort of highlights the work of the lawyers led by the Southern Poverty Law Center that pursued that case on behalf of those guest workers. And this is a video to salute them for the work that they did in this particular case.
When Hurricane Katrina hit the Gulf Coast, it was devastating for the region. Signal International, which is in the business of manufacturing and repairing ships and oil rigs, had the opportunity presented to them by a recruiter based in Mississippi. He could get Signal's skilled welders and fitters from India to work on these rigs. Signal would not have to pay a penny to bring them to the United States. And they would have workers who, by virtue of their visa, are tied to that employer. The workers were told that they would be coming to the United States on permanent residence visas. What the workers didn't realize is that guest worker visas, and one is temporary, one is permanent. Some of them even paid $25,000 for this opportunity to come to work in the United States. And when they arrived at Signal's facilities, what they found was shocking. 24 men living in double-wide trailers, no privacy. Their belongings were searched as they came and left. Illness being just widespread at the labor camp. Discrimination and harassment and disparaging comments at the workplace, working in the bowels of these rigs, doing the most dangerous welding and fitting work. And not only were they forced to live in this labor camp, but they were required to pay $1,050 a month each to live there. And then little by little, the workers realized that these green card promises were lies. When they started to complain, to talk amongst themselves and talk to lawyers about their conditions, Signal engaged in a roundup of some of the leaders of this organizing effort with plans to forcibly deport them. And then in March of 2008, we had filed this case as a class action, claiming that the workers were subjected to labor trafficking, racketeering, discrimination, contract violations, common law fraud. The class was not certified. And Signal considered that to be a huge victory. And the result was 12 separate lawsuits filed on behalf of close to 250 workers. We were provided with 2.5 million documents. The levels of discrimination, of collusion and fraud, we were able to prove with these documents, some of which were just appalling. The extent to which Signal profited was very evident through these documents. We had a 5-week trial, an incredible team effort, and I've never had a collaborative effort that can come close to matching what we had here. The result of the trial was a $14.1 million verdict for the first 5 plaintiffs to go to trial. Something that was really impressive about this group of clients was that they stuck with it. The Signal did whatever it could to delay this case, and these workers persevered. And in the end, having stuck it out for 7 long years, they achieved real justice. This case is about getting justice for our clients, while at the same time highlighting deep flaws in our guest worker program that allowed these kinds of abuses to take place, and about sending the message both to this company and to other employers that they won't get away with this kind of behavior.
Are y'all still able to hear me?
We can.
Is everyone able to hear me, Renee?
Yep, you're good.
Great, thank you. So let's ask an important question. When should a survivor consider filing a civil case? Well, the first thing that I think needs to be asked, and always the predominant question, is what is in the best interest of this particular survivor? And that should always be the guide. That should always be the lighthouse for us in reviewing whether or not a civil claim makes sense. It is something that needs to predominate the evaluation at all times. And particular considerations that have to be discussed. First of all is the statute of limitations. We talked about that 10-year period, and obviously it's going to vary under different state laws as well, and various tort claims that can be brought. But as it relates to the federal civil remedy, that 10-year period, where are we in that? Preservation of evidence is obviously important. When there is a civil claim, sometimes it will include defendants that were not part of a criminal case. And a lot of times it will be necessary that the civil case be initiated so that evidence is not lost. And that is a factor that needs to be considered. Lastly, is there a parallel criminal case ongoing? And does that case need to play itself out first? Obviously, a conviction of the trafficker necessarily helps a civil case. So if there is an underlying criminal case pending, maybe the best path would be to allow that to play out if there's significant enough time or ample enough time left on the statute of limitations, and that's what's in the best interest of the survivor. One thing that I think is important to point out here is that there does not have to be a criminal case and there does not have to be a criminal conviction for a survivor to have a civil case. I don't think that can be emphasized enough, that there does not have to be the first domino of a criminal case or a criminal conviction for a survivor to have a right to file a civil claim. Clearly, it is something that is beneficial, not only because someone was held accountable criminally, but also because, there's a parallel criminal investigation that can help a survivor in their pursuit of their civil claims. But I don't want to give the wrong impression today that there has to be a criminal conviction in order for a survivor to have a civil claim. There doesn't even have to be a criminal charge for a survivor to have the right to bring a civil claim. What should a survivor expect from the civil justice system? I think these are important things to distinguish. In the criminal justice system, obviously, those cases are brought by the United States when it's a federal crime, and brought by a particular state or district attorney when it is a state crime. And the survivor is not a party to that case. That victim is not a party to the case. In a civil case, the survivor brings the claim. They are the plaintiff. They are a party to the case. And with that is inherently more control. They get to pick, first and foremost, who will be their lawyer, who will be their advocate, who will be their soldier in this fight for civil justice. In the criminal context, the victim doesn't get to pick who the prosecutor is. And it is that control and literally the ability to confront your traffickers and confront those people who turned a blind eye to the trafficking empowers the survivor. And that is a great advantage of the civil justice system over the criminal justice system. Another advantage, obviously, because someone's liberty is not at stake. We're not trying to put someone, take away their liberty and possibly put them in prison. The burden of proof in a civil case is lower than the burden of proof is in a criminal case. So the criminal case has the highest burden of proof under our judicial system, and that's obviously beyond a reasonable doubt. In the civil context, it is a preponderance of the evidence, more likely than not, anything over 50%, and the plaintiff has met their burden of proof. Another thing that should be explained to a survivor in advance of filing a civil claim is that it is an adversary process. That is how our justice system is set up. It is the plaintiff versus the defendants. And in any adversary process, it can be taxing. The other side is obviously the opponent. Those lawyers that will be representing the defendants in these cases will have jobs to do. And in doing those jobs, sometimes it will challenge the survivor and their will to pursue their civil remedy. It is important to point out on the front side that the discovery process can be taxing, that there will be questions that have to be answered about the trafficking period. What happened in the trafficking period? And answering those questions is sometimes can be re-traumatizing. So again, going back to the overriding question, what's in the best interest of this particular survivor? Where are they in the path to becoming a survivor? And then lastly, we need to be able to explain that it is not generally an overnight process, that typically this can take upwards of 2 years, sometimes more. In the event that there are appeals and other issues, number of defendants, it can even go over 2 years. But generally speaking, 2 years is around a good general number as to the length of time a case takes from start to finish in a trafficking context. I can't emphasize this point enough because of the fact that you're dealing with survivors of human trafficking who have obviously been through horrific trauma, that the litigation needs to be pursued by someone who, number one, is trauma informed themselves, or is willing to get the training on being trauma informed in the pursuit of these cases. Separately, a lawyer needs to factor in all considerations, proceeding anonymously or under a pseudonym so that the survivor's name can be protected from the public record. If that's an available option, it definitely must be explored. And courts are generally receptive to that approach in a human trafficking context, especially in a sex trafficking context. They are more inclined to allow a survivor to pursue a case either under a pseudonym or anonymously. The discovery process needs to be explained at length, that there will be questions that we talked about that are more formally referred to as interrogatories. There will be requests for production of documents relative to treatment or care that someone may have had as a result of their trafficking. And there's a lot of things that need to be considered between a lawyer and a survivor when factoring in a trauma-informed approach and what claims to make and what damages to claim. These are some of the factors that we consider when we are looking at whether or not there's a viable claim to bring that could potentially result in a meaningful recovery for a survivor. First, are there defendants who would have the resources to satisfy a judgment? The last thing that I want to do would be put someone through that grueling adversarial process, be successful in obtaining a judgment, and then ultimately not have the ability to recover on that judgment. And if that is not something that there's a defendant from which to recover from, that needs to be explained to a survivor on the front side. Doesn't necessarily mean that you don't ultimately pursue some cases where there may not be a defendant with the resources to pay the judgment. There is an empowering element to getting a judgment against your trafficker, knowing, especially in the context where there was not a criminal prosecution or a criminal conviction. And that alone can have substantial value to a survivor. But on the front side, because all that can be asked for under the civil remedy provision is damages, you want to make sure that one of the things that you're talking to the survivor about is whether or not there is the potential for having a meaningful judgment paid. Going back to the overriding question is, will the survivor be in a circumstance where they're going to be available to assist in the prosecution of their own case? Are they going to be available for discovery? Are they stable enough to endure what could be a multi-year process? Those are all important questions to ask on the front side. Are the defendants in the case in the United States? How difficult will it be for this survivor to pursue their civil claims? And what laws will be applicable to the defendants? Those are important questions that need to be considered, especially in a labor trafficking context. Safety concerns. Is the trafficker incarcerated? How long will the trafficker be incarcerated? Who are the trafficker's affiliates or contacts that may not be incarcerated? How can we ask a court to set in place certain protections for the plaintiff or the survivor as he or she pursues her claim? Those are things that need to be factored in, and especially in a context where either the trafficker has been convicted but is no longer incarcerated, or where the trafficker was never convicted. Are there other potential plaintiffs? This can sometimes not only support the survivor in their own case. We all know from the child sex abuse context that where there are more survivors that have reported, it only increases the strength of a particular plaintiff's case. And especially in the context where someone knew or should have known, when there are multiple victims of a particular trafficker that can be identified, it is more difficult for, say, for example, a hotel or a motel to say we had no idea what was happening when, multiple rooms are being rented and multiple people are being victimized by the trafficker. How can the civil case potentially impact the criminal case? A lot of times the decision is made to hold off on a civil case until the criminal case is concluded. Sometimes that option is not available because of various deadlines, such as statute of limitations. And so before you file a case, if there is an underlying criminal case, you would want to have a discussion with the survivor and potentially the prosecutor about the potential impact of filing a civil case on a criminal case. And lastly, and this is more particularized, what will filing a civil case, what impact could it have on your own client's immigration status? That is something obviously especially important to foreign nationals or the undocumented persons. How can we maybe use other vehicles within the system to help protect them? There are things called T visas or trafficking visas that can help a survivor stay in this country during the pendency of their case. I think this particular quote speaks volumes, and I have it even on my own website for my office, that telling the truth about terrible events such as human trafficking helps us, number one, restore social order, and number two, it helps the individual victim heal. Knowing that they're being heard, knowing that their story will be told. These are all important factors in analyzing a survivor's claim. I need to address, I think I told you earlier, I would talk about sort of the landmark cases, both in a labor context and a sex trafficking context. In the labor context, we looked at the video on the Signal International case. In the sex context, I think it is important to point out, for the purposes of today's webinar, the Riccio v. Shangri-La hotel case, which last year settled after 5 years of litigation. And the Riccio case is so important because I believe it to be the first filed by a survivor under that Section 1595 against a hotel or a motel where a sex trafficking venture was hosted or operated out of. And ultimately, the court in Riccio refused to dismiss the survivor's claims, saying, yes, they do have a right under 1595, and they do have a right under this negligence standard, this should have known standard, to bring a civil claim against this hotel that knowingly benefited. Ultimately, that case settled last year for a confidential amount, but I think it is important for everyone on this call to know that a survivor has brought a claim against a business that did not get criminally charged and has held that business responsible under the civil remedy provisions of 1595 for their actions in enabling a sex trafficking venture to operate out of its hotel. I think we are approaching the hour, and I would like to go ahead and take questions. Renee, I'm not sure if you're able to read those off. Okay.
I am. You are correct. We are right at the hour. Man, you're good. So let's start with the begin. I'm going to go through the questions out of order to try to get you from the beginning and do something that makes sense here. So how does a restitution award in a criminal case affect a civil case? And then there was a parallel question of who exactly pays the remedy for the victim, and if a state doesn't have a provision for a civil remedy, does a person who's been trafficked need to file a lawsuit in federal court? So lots on restitution and remedies and who pays and what if the state doesn't allow it?
All good questions. First of all, if I forget one, Renee, please remind me of it. Restitution.
I will.
All right, restitution obviously is generally something that can be computed at the time. It is not looking at what we call prospective damages or future damages. It is looking at maybe, for example, what are your lost wages for those folks that were in a forced labor context where they were being charged for their uniforms or rent, and they're making 50 cents an hour as opposed to the $12 an hour that they were supposed to be making. Those are the types of things that restitution can account for, past concrete numbers of damages. Civil claims can look more prospectively at, like, what are my future lost wages? Do I now not have vocational opportunities because of this trauma, because of my PTSD? I know I will need long-term mental health care. Those are the types of damages, and candidly, mental anguish associated with the pain of going through the trauma. Those are the types of claims and damages that can be recovered in a civil case that aren't necessarily easily fitted into a restitution award. The restitution awards are obviously made against the criminal defendant. And a lot of times that's the trafficker, the perpetrator. And they may not even have the means to pay the restitution they're ordered to pay. And so it is not something that, say, a civil defendant, that is the hotel, is necessarily paying. If you name the trafficker in your civil case and they separately had a restitution order, then there could be an offset of those damages that are made against the trafficker in a later civil case. But completely distinct categories of damages. As it relates to a state where there is not a human trafficking civil remedy in the state law. Obviously, the federal law is available to those survivors. In those cases, if they're filed under the federal case, would need to be filed in federal court. However, a lawyer should separately analyze whether or not there are traditional tort claims that could be brought in state court if federal court was not a preferred venue where you are. And, traditional state court tort claims would include simple negligence or premises liability. Did a hotel fail to protect against a known danger or something they knew or should have known was a danger? So there are more traditional tort remedies that can be evaluated even when there's not a state-specific statute on it. But obviously the state statutes, because they sometimes build in additional damages, whether it's treble damages, attorney's fees, punitive damages, those are the types of things that if they're available, then you obviously want to use those vehicles if they're available. And I think
you got them all. And I was remiss in not saying this, but I see people rolling off, but a lot staying on. If you're rolling off, again, we are going to have this available both on victimbar.org and on our YouTube webpage. And everybody sees Greg's email and website, and he is welcoming questions as well. So back to the questions, and one that ties in, if a trafficker is found not guilty in criminal court, how much does that impact your civil case?
Well, it is not what we call like issue preclusion. Obviously, going back to the burden of proof standard we talked about before, and I hate you having to look at me on such a small screen, but the burden of proof in a criminal case is beyond a reasonable doubt. And the burden of proof in a civil case is a preponderance of the evidence, or 50% or more than just over 50%. The most classic example that I can give that people may have an immediate understanding of is that O.J. Simpson was found not guilty in the criminal case, but he was found liable in the civil case. So it does not stop someone from bringing a civil case just because in the criminal court they may have been found not guilty. However, if they are found guilty in this higher standard, it can have issue preclusion, meaning that's already been determined in the civil case because the person has been proved or admitted beyond a reasonable doubt to their guilt to the crime.
So likewise, have you found prosecutors' offices tend to not share during criminal cases? And then what is the FBI's role in a civil case? Can they be called as witnesses? How do they play a role in civil cases?
So law enforcement, from the first responding officer to the prosecutor, obviously all have important roles in the criminal investigation and prosecution. The evidence they collect is obviously something that is helpful and meaningful to a civil lawyer in the pursuit of the civil case. As far as their willingness to assist, I'll just tell you that varies from prosecutor to prosecutor. Some are more willing to work together during this investigation stage, and obviously I share with prosecutors all the time things that I think may be, are fruits of my investigation that may be helpful in the prosecution of their case. But clearly they have a job to do and they want to focus on doing their job, and they certainly don't want to jeopardize that by opening up information to people outside of the prosecution team. So there are times where we literally sit on the back seat until the criminal case is concluded. But in the interim, I'm always offering up to prosecutors things that our investigation has revealed, just to make sure their investigation has revealed the same thing. When it comes to prosecution, to witnesses, it would be extraordinarily unusual for a prosecutor to ever have to testify in a civil case, but law enforcement officials traditionally are called as witnesses in civil cases, especially when it is someone that maybe encountered the survivor at the scene when they're rescued. So they may have like hard and fast factual information that can be beneficial to the trier of fact or the jury in the civil case.
So some substantive questions on human trafficking. What is it, do you think, what makes people more vulnerable during a pandemic to trafficking?
Well, obviously a lot of things. I think number one, the isolation we talked about, especially for in that domestic work context. So that isolation factor amplifies it. Separately, there are a lot of people now that are out of work. And, you know, in an effort to survive, they may be more vulnerable to being trafficked by someone. And, you know, sadly, traffickers, they prey on those vulnerabilities. I mean, they exploit them for financial gain. And in a situation where you've got increased poverty, increased unemployment, you've got more people that are vulnerable.
And then when we're talking about undocumented individuals, do we worry that bringing their case to the attention of courts might increase the risk of deportation?
That's, you know, here is something that I think is important. And we talked about the T visa options. And I think in large part over the years, the allocations of T visas had been underutilized. Those are trafficking victim visas that allow them to stay here legally during the pendency of their case. Whenever I'm faced with a situation with someone who's undocumented that could be a potential plaintiff in one of my civil cases, it only makes sense to enlist the help of someone who's an immigration attorney so that we are exploring all the protections that may be available so that we do not find ourselves in a circumstance where we have compounded problems for a survivor.
And then if there's a youth that is fitting under multiple or both categories of both labor and sex trafficking, are they counted more than once? Does one category outweigh the other? Does it matter?
I think it would be up to whatever organization is keeping that count. Candidly, we see that what I call an overlap or hybrid situation where someone maybe takes a job in a gentleman's club. I hate to even call them that, but ultimately is sex trafficked out of that. So you had a labor situation that becomes a sex trafficking situation. As far as like how particular organizations would categorize those, I can't speak for all those organizations. I do know that if we were pursuing a civil claim, the options would include both a violation of the labor trafficking portion of the TVPRA and the sex trafficking portion of the TVPRA. So claims could be made under both. You don't have to choose one or the other.
Okay. Back to taking the cases and working through the cases. How does the survivor pay her attorney if she's unable to do so, or he? So do most attorneys doing this work on contingency or? Yeah,
so there's been a couple of ways that these cases have been pursued. My office and in all the cases that I pursue on behalf of crime victim are handled on a contingency basis. So that means that there is access to hopefully a group of lawyers that are qualified, that have experience in pursuing these claims on behalf of crime victims, trafficking survivors, and because they're handled on a contingency basis, the survivor doesn't have to come out of pocket to pay for that lawyer. The lawyer takes the risk of the expenses of pursuing that case because they believe in the case, they believe in the survivor, and that lawyer will not be paid for their time, will not be reimbursed for their expenses unless and until there's a recovery. So that obviously is an important factor in making sure that there's quality lawyers available. Separately, there are a lot of, in this context, of firms that are handling these cases on a pro bono basis, because the TVPRA has a built-in attorney's fee provision that would ultimately, in a successful claim, allow for the payment of attorney's fees. These cases can be oftentimes pursued on a pro bono basis in certain contexts. But when you've got claims where you're analyzing tort claims under state law, you're analyzing tort claims against what I'll say non-criminal culpable defendants, the ability to have access to lawyers on a contingency basis is absolutely critical to getting survivors into the hands of a competent attorney with experience, and one that, again, is trauma-informed.
So in civil cases, do you have usually an advocate sitting with the victim similar to a criminal case where the person's providing more of the emotional support, or is it usually just you and the victim?
Typically at counsel table, it is my team and the victim. There's not anyone in my office who is quote unquote the victim advocate, although my entire team has been through trauma-informed training so that we can obviously not intentionally or unintentionally avoid any re-traumatization by anything we may say or do. I have actually seen victim advocates from the criminal context continue to support the survivor even after the conclusion of the criminal case, and have been sounding boards throughout the civil case as well if it happened after the fact. But generally speaking, one of the things that is an important component of damages is the future mental health care component. And typically a survivor, when you're analyzing that damage component, may already be receiving mental health care from a counselor or some other mental health professional that is sort of by their side through this process.
Perfect. And we've got 2 questions left. I'll let you decide which one to take, or if you can talk quick, take both.
I can take both, I'm sure.
For beneficiary liability under 1595, what are your thoughts on how direct the benefits need to be?
Well, obviously, the room rent in the Riccio case is a good indicator. Courts are still exploring that. And there's a couple of cases out of Ohio that if whoever asked that particular question wants to email me, I'm happy to give them the specific rulings from that case about how that particular court is interpreting how direct the benefit needs to be. But candidly, the should have known component is something that's factoring in to the beneficiary. So clearly a room rental and is enough of a hook for the knowingly financially benefiting from something. Doesn't necessarily have to be the John paid X dollars, here is Y percentage of X dollars direct to you.
Got it. And then the last one, if trafficking was primarily done for non-monetary value, example, gangs that traffic girls as favor, does that affect what can be done in a civil case? No,
I mean, obviously, it would go back to the overriding question we analyzed and what should be considered. And that would be number one, is there the potential for a meaningful recovery? Is there a defendant that could pay a meaningful recovery? Ultimately, anyone who's trafficking someone has a motive, and that motive usually ends at some sort of monetary motive. And it would be, that would be a case-by-case analysis, even if the actual victimization didn't include the exchange of money.
We are at 1:16, so we went even a minute over. Thank you everyone so much for joining us and for your questions. And Greg, thank you so much for giving us this. It was wonderful.
thanks to all of you. And again, I challenge you to please try and identify just one case that you might be able to help the survivor on as far as knowing their rights under the civil justice system. And in doing that, we will have amplified Congress's intent with that remedy. But I appreciate everyone being in attendance. Thank you.
Perfect. Thank you.